Residential Listing Agreement, Exclusive Authorization, and Right to Sell. CAR Form RLA. The Residential Listing Agreement is a contract between the owner or owners of residential real property and a real estate broker. By entering into this contract, the owner agrees to hire the broker as an exclusive agent to sell the property. The owner also agrees to compensate the broker for procuring a ready, willing, and able buyer during the listing period whose offer is accepted and closes. Paragraph 1. Exclusive right to sell. This paragraph provides the broker with the exclusive right to sell the subject property. For seller, list the names of all sellers. In most situations, the sellers should be the owners of the subject property, the persons who intend to sell the property, and the persons with authority to both list and sell the property. See also ownership, title, and authority in paragraph 24. If one or more of the sellers is an entity, such as a corporation or LLC, or a trustee of a trust, then identify the entity seller, not the signing party for the entity. Using a shortened version of the name of a trust or trustee is acceptable, provided the full name of the seller and legally authorized signer for the seller is included in the entity seller paragraph in the signature section. Practice tip. Before taking a listing, it is a good idea to obtain a property profile or check the public records for the subject property. Use this information to verify that the sellers entering into the listing agreement matches exactly with the owners of record. If the purported seller is not the owner of record, or not the only owner of record, the listing agent's efforts in listing and marketing the property might turn out to be a waste of time. For broker, insert the name of the listing broker. The seller enters into the listing agreement with the real estate broker or brokerage, not the individual salesperson or broker associate. The paragraph of the residential listing agreement is in grid format. The information placed into the blank lines in the grid are not for summary purposes, but instead form the contractual agreements of the parties. Rows in the grid reference the paragraph later in the RLA that contains additional language that provides further explanation of the grid terms and contractual agreements that bind both the broker and the seller. Those paragraphs are all important, and sellers should read them in their entirety. For beginning date, insert the calendar date the listing period will begin. The listing period should begin, if possible, on the day the parties enter into the listing agreement. This is because the seller is less likely to have misgivings about the listing if the listing agent immediately begins advertising and marketing the subject property. Of course, in some situations, the listing agent has no choice but to schedule the listing period to begin at a later date, for example, when waiting for a prior listing agreement to expire. For ending date, insert the calendar date the listing period will end. Always fill in this blank with an ending date. A listing agent cannot claim, demand, or receive a commission under an exclusive listing agreement unless that agreement contains a definite, specified date of final and complete termination. See California Business and Professions Code, Section 10176F. Determining the proper length of time for a particular listing requires a careful weighing of various countervailing factors, such as the listing price, the condition of the property, the parties' requirements, and market conditions. If the listing period is very short, for example 30 days, the listing agent may spend a lot of time, money, and effort to market the property, yet not find a buyer nor earn a commission within the specified time. On the other hand, if the listing agent insists on a lengthy listing period, for example 12 months, the seller may distrust the listing agent's ability to sell the property. The maximum listing period allowed by law is 24 months. It is unlawful to file the listing agreement with the county recorder. If a listing agreement for any lawful period is extended or renewed, the maximum time for such extension or renewal is 12 months. Paragraph 2A2. Listing price. Write out the listing price using words and, in the parenthesis after the $, using numbers. The list price usually is the target price at which the seller is willing to sell the property. As with the listing period, Determining the correct list price requires a careful balancing of various factors, including, among other things, the condition of the property, the party's requirements, for example, how quickly the seller wants to sell the property, comparable sales, and market conditions. If the list price is too low, the seller may get frustrated receiving a lot of offers that never amount to anything. If the list price is too high, the seller may get no sales activity at all. 2B. Property-specific listings. If the property is a manufactured home or the sale is part of a probate, conservatorship, or guardianship, check the appropriate box to add the manufactured home or probate addendum. Paragraph 2C. Compensation. 2C1. Compensation to seller's broker. Insert the amount of compensation seller's broker is to receive from seller solely from the seller's side of the transaction. This can be entered as a percentage of the list price, or actual purchase price with an option to add an additional sum, or this can be written as a dollar amount, or the broker can create a schedule to outline how compensation will be paid. The advantage to the seller of paying a commission rate is that it gives the broker an incentive to bring as high of an acceptable offer as possible. On the other hand, by using a flat fee, the seller will know exactly how much the broker's commission will be, regardless of the sales price. Check the appropriate box and insert either the commission rate or amount. Keep in mind that for 1 to 4 residential units, the broker should never pre-print the commission rate or amount. See California Business and Professions Code, Section 10147.5b. 2C2. Optional. Additional compensation to seller's broker if buyer is unrepresented. Insert an amount of additional compensation the seller's broker will receive in the situation where buyer is unrepresented throughout the transaction. Inevitably, in this circumstance, the buyer will not have the help of their own agent, so the seller's agent will have to do more work as a facilitator and liaison to open doors, meet inspectors, communicate with escrow. The seller's broker will not be the agent of the buyer and is not a dual agent, but because of the extra time constraint and administrative work that will need to be done, this paragraph may be used to negotiate with the seller if they are willing to pay an additional compensation, recognizing the extra effort the seller's agent will have to do. Paragraph 2C3. Continuation of right to compensation. This subparagraph is the safe harbor provision. To avoid paying the broker's compensation, a seller may be tempted to reject an offer from a buyer procured by the broker, only to sell the subject property to the same buyer after the listing period ends. The safe harbor provision reduces the possibility of this type of abuse by protecting the broker's compensation for a certain number of days after the listing period ends, called the continuation period. Paragraph 4D2 explains the rules pertaining to the continuation period. Insert the number of days after the expiration or cancellation that the broker wants to set as the continuation period. Determining the proper number of safe harbor days requires a weighing of various factors. The broker has very little protection. On the other hand, if the broker demands a lengthy safe harbor period, like 12 months, the seller may not give the listing to the broker. 2C4. Seller's obligation to pay previous brokers. Identify any prior listing agents with whom the seller has previously entered into a listing agreement, and list the names of the prospective buyers procured by that agent. This should be filled out, and the terms of paragraph 4F explain how it will pertain to this listing agreement, and the protections for the broker and seller related to the previous agents and protected buyers. Even if a listing period has ended, a seller who had a listing agreement with broker A will not want to enter into a new listing agreement with broker B during broker A's safe harbor period. See paragraph 2C3. Otherwise, the seller risks being obligated to pay full commissions to both brokers if a buyer procured by broker A buys the property during both broker A's safe harbor period and broker B's listing period. To avoid this result, Paragraph 2C4 allows the seller to exclude prospective buyers procured by Broker A from Broker B's listing agreement. Broker B will not receive any compensation if anyone on this list buys the property. A prudent listing agent in Broker B's position will carefully review the terms of the seller's listing agreement with Broker A and verify that Broker A's list of prospective buyers has been timely and properly submitted to the seller. Also, if Broker A's safe harbor period ends before Broker B's listing period ends, Broker B is entitled to compensation if the sale occurs after Broker A's safe harbor period ends. For example, Broker B takes a listing from January 1st to April 30th, but Broker A's safe harbor period for certain buyers ends March 31st. Broker B would be entitled to compensation for a sale to a buyer named in paragraph 2C4 entered during April. Paragraph 2D. Items intended to be included and excluded. A sale will include all fixtures and fittings attached to the subject property. Fixtures are items that become so related to a piece of real property that they become part of the sale of that real property. In contrast, items of personal property are not included in the sale of real property, unless specified otherwise by contract. Whether an item is a fixture or personal property is a question of fact to be determined on a case-by-case basis. Many items are obviously a feature, like the roof, or personal property, like a lawn chair. But some items are not so easily characterized, for example, custom-made drapes. 2D1. Items included in sale. List any and all items of personal property to be included in a subsequent sale. Whenever in doubt, simply list any and all items the seller wants to include in a subsequent sale, such as appliances, custom-made items, and the like. 2D2. Items excluded from sale. List any and all items attached to the subject property to be excluded from a subsequent sale. When in doubt, list anything attached to the property that the seller wants to exclude from a subsequent sale. Pay particular attention to the items out of the ordinary, such as family heirlooms, chandeliers, antique fixtures, etc. 2D 3, 4, and 5. These sections are used to clarify whether any item which might otherwise be fixtures or leased are subject to some type of lien securing payments related to the items or are smart features. Common examples include leased or liened solar panels and propane tanks. To avoid confusion and assist the broker in marketing the property and helping the seller complete or counter an offer, it is best to identify leased items, liened items, and smart home features. Paragraph 2E. MLS and Public Marketing. 2E1. This paragraph will disclose which MLS the broker is using as the primary MLS and can name other MLSs being utilized. It also references the MLS addendum, which outlines more MLS-specific terms and rules. 2E2. This outlines where a broker is authorized to state that the seller is willing to consider offers asking for concessions, both in the MLS and in other materials. It also states that the specific amount will not be stated unless the seller notifies broker in writing of the specific amount. 2E3. Photographs are helpful and common ways to advertise the property, but sometimes sellers may not want photos of their house published. This paragraph can be checked to opt out of using photographs in marketing. Paragraph 2F. Broker and seller duties. 2F1. time of presentation of offers. Most of the time, sellers' agents will immediately submit offers they receive to the seller. However, some sellers may want to gather offers and present them all together on a certain date. This paragraph gives the option to have offers submitted on a certain date or a certain number of days after being active on the MLS.
I love you.
I love you too.
2F2 Buyer Supplemental Offers. Buyers may try to submit supplemental letters, love letters, to the seller to try to persuade the seller to sell to them. Oftentimes, these may identify certain characteristics that could become fair housing issues. For this reason, it is safest not to consider supplemental letters. This paragraph defaults to removing any letters, but provides an option for seller to instruct otherwise over the advice of the seller's broker. 2F3 Investigation Reports. Often, sellers may decide to get inspections done ahead of time, either to address issues or to have the reports available for any buyers in order to shorten the process and contingency period. This paragraph gives a variety of inspections that may be ordered before entering into contract. The natural hazard disclosure is pre-checked because this form will be needed in all residential 1 through 4 transactions, and sellers will need to know as early as possible if they are required to do additional disclosures related to fire hardening and defensible space. Paragraph 2G Exceptions to ownership. The seller warrants that he or she owns the property, that no one else owns the property, and that the seller has the authority to both enter into the listing agreement and any subsequent sales contract. Any exceptions to these warranties of ownership, title, and authority should be explained under exceptions. Paragraph 2H Seller Contingency for Replacement Property. This paragraph can be used to inform the seller's agent that the seller desires to add a contingency to any purchase contract to be able to locate and purchase a suitable replacement property. This allows the seller's agent to be informed and know that this is something that will need to be added and considered when entering into a contract with a buyer. Paragraph 2J Opt-outs. This is to opt out of the use of a key safe, lockbox, and or the use of a for sale sign on the property. Paragraph 2K Additional terms. These are blank lines for the broker and seller to add additional terms that aren't otherwise addressed in the listing agreement. Paragraph 3 Advisories and Addenda. This paragraph is used to attach additional documents to the listing, including the broker compensation advisory, which provides information to the seller about how compensation works in the transaction. If the seller is a trustee of a trust, then the trust advisory box should be checked. If the seller is an REO or the transaction will be a short sale, then check the appropriate box. Paragraph 4 Compensation to broker. This paragraph contains the underlying terms and conditions of the broker's compensation indicated in paragraph 2C. The notice provision must be set forth in not less than 10-point boldface type on any printed or standard form agreement establishing or altering a listing agent's right to compensation in the sale of 1 to 4 residential units. See California Business and Professions Code, Section 10147.5a. The large, bold notice makes it more likely than not that the seller is aware that broker compensation is not established by law, even though compensation is negotiable. A broker can establish a rate below which the broker is not willing to work, given the expected time and resources anticipated for marketing the property and ushering a sales transaction from contract to closing. Paragraph 4a. Advisory. An additional statement that commissions are fully negotiable to satisfy requirements and to reiterate the concept to the seller. Paragraph 4b. Compensation to broker. The corresponding explanation to paragraph 2c1 that explains that the seller will pay the amount specified. Paragraph 4c. Optional additional compensation for unrepresented buyer. An explanation for paragraph 2c2 that further explains the situation where the buyer will be unrepresented, that the seller will pay the broker an additional amount for the extra work involved. This does not apply if the buyer is represented by any agent, including if the seller's agent becomes a dual agent. Paragraph 4d. Compensation terms. 4d1. By entering into this exclusive listing agreement, the seller agrees to compensate the broker as long as anyone procures a ready, willing, and able buyer during the listing period. The seller accepts the offer and the transaction closes. It makes no difference if the procuring cause is the broker, the seller, a cooperating broker, a neighbor, anyone else, or no one at all. Sometimes the seller will not be willing to compensate the broker for a buyer procured by the seller. In that situation, the seller reserves the right to sell the property without paying the broker, and the proper listing agreement to use is the Residential Listing Agreement Seller Reserved, CAR Form RLASR. If the seller refuses to compensate the broker for a buyer procured by anyone other than the broker, the proper listing agreement to use is the Residential Listing Agreement Open, Non-Exclusive Authorization and Right to Sell, CAR Form RLAN. Paragraph 4d3. The broker is entitled to full compensation if, without the broker's consent, the seller withdraws the property from sale, transfers the property, or renders the property unmarketable. Paragraph 4e. Additional compensation terms. If a subsequent sale falls through at no fault of the seller, the broker's compensation is limited to 1/2 of whatever the seller collects as money damages, not to exceed the agreed-upon commission, plus the administrative transaction fee. Also, this provision entitles the broker to receive his or her compensation through escrow, thereby avoiding any problems of collecting such funds from the seller directly. Also, the irrevocable assignment language means that the seller agrees not to revoke, cancel, or put on hold any instruction to escrow to pay such compensation to the broker at close of escrow. Paragraph 4f. This paragraph refers back to the previous listings and protected buyers listed in paragraph 2c4. The seller is representing that the seller does not have any obligations to another broker or any other obligation to pay another broker unless specified in paragraph 2c4. For anyone that is listed in paragraph 2c4, this paragraph explains that the broker is not entitled to compensation and that the broker is not obligated to represent the seller. The seller will need to make a decision on how to proceed if one of those protected buyers makes an offer and seller wants to move forward with that buyer. Paragraph 4g. This explains that there is a law that sets a maximum period for listings on residential 1 to 4. The maximum length of these listings is 24 months. However, this limitation does not apply if the seller is a corporation, LLC, or partnership. Additionally, a listing may not be recorded with the county recorder. Paragraph 5a, 5b, and 5c. Items excluded and included. Leased or liened items, smart home features. These paragraphs outline issues related to items in the property that may be included in a sale and instructs the seller that they need to inform the broker of any items they do not want to include and also other documentation or information that may be needed as part of the sale. Paragraph 6. Seller representations. The seller represents that seller has no knowledge of certain facts likely to affect the marketability of the property, such as recorded notices of default, delinquent obligations, bankruptcies, pending or threatened lawsuits or other actions, and special assessments. If the seller becomes aware of the existence of any of these facts, seller shall give a disclosure to the broker. Paragraph 7. Brokers and sellers' duties. The broker agrees to work diligently to achieve the purposes of the listing agreement. The broker has the authority to advertise and market the property in any medium, including the internet. The broker will present all offers as soon as possible unless seller gives written instruction otherwise. The broker will present all offers as soon as possible unless seller gives written instruction otherwise, as set forth under paragraph 7B2B and 2F1. There is information about supplemental offer letters, love letters, and the risk under fair housing that are associated with their use. The default is for the broker not to present such letters, with an opt-in checkbox with a warning to the buyer about improper use of such letters. Seller agrees to consider all offers, to act in good faith to sell the property, to make the property available for showings, to refer all inquiries to the broker, and to assume responsibility for determining the list price. The seller can agree to pay for certain pre-sale reports, which may facilitate the sale of the property. The seller also agrees to indemnify, defend, and hold the broker harmless from all claims arising from any misrepresentation or concealment of fact made by the seller. Paragraph 8. Deposit. The broker has the authority to accept and hold, on the seller's behalf, any earnest money deposits received. Paragraph 9. Agency relationships. 9A. Disclosure. The seller will be provided with the disclosure regarding real estate agency relationship, CAR Form AD. The AD form is attached. The agency disclosure form, which sets forth the various types of agency relationships, must be provided by the listing agent to the seller prior to entering into the listing agreement. See California Civil Code, Section 2079.14a. Both the seller and the listing agent should sign and date the disclosure form where indicated. Paragraph 9b. The broker will represent the seller in any subsequent sale of the property. Paragraph 9c. The seller consents that upon proper disclosure, the broker may act as a dual agent representing both the buyer and the seller. Seller acknowledges that buyers will need to have an agreement with an agent working with them before showing, and that broker may enter such an agreement and become a dual agent. The seller consents that the broker may have other listings and other clients. The CAR Form PRBS, possible representation of more than one buyer or seller, is attached. Both seller and listing agent should sign and date the form where indicated. (9D). The seller authorizes broker to obtain a document, such as a buyer non-agency form, from a buyer who is and will remain unrepresented during the transaction in order to clarify that agency relationship and that the buyer will not be represented by broker. (9E). The broker agrees to confirm his or her status as an exclusive seller's agent or to modify his or her status to dual agent before the seller enters into a sales contract. (9F). This paragraph explains that the agency relationship ends at the expiration of this agreement or completion of the described transaction, whichever occurs first. Paragraph 10. Concessions. This paragraph explains what concessions are and gives examples so that seller is aware of the possibility that an offer may include them and how they may be communicated and advertised to potential buyers. Paragraph 11. Security, insurance, showings, audio, and video. The seller agrees that the broker is not responsible for any loss or damage caused by using a key-safe lockbox or by showing the property. The seller is advised to take all reasonable precautions for safeguarding the real property and its contents, and to obtain insurance to protect against any risk. The seller is advised to post notices advising prospective buyers of the presence of audio and visual recording devices. Paragraph 12. Photographs and Internet advertising. The seller acknowledges that photographs and Internet advertising can enhance the marketing of the property, but that once images are posted on the Internet, there is no ability to control who can view them or how long they will remain available. Seller also agrees the images are the property of the broker. If the seller does not want the broker to take photos, the seller should opt out in paragraph 2E3. If the box in paragraph 2E3 is checked, the seller instructs the broker to place an instruction in the MLS prohibiting others from taking photographs, but acknowledges that others may take photos anyway. Paragraph 13. Key-safe lockbox. The broker is authorized to install a key-safe or lockbox on the property, unless the box in paragraph 2J is checked, withholding that consent. There is a warning that if the property is tenant-occupied, the seller is responsible for getting written permission from the tenant if they are authorizing the use of a key-safe lockbox. Paragraph 14. Sign. The broker is authorized to install a for sale or sold sign on the property unless the box in paragraph 2J is checked, withholding this consent. Paragraph 15. Equal housing opportunity. Both the seller of real property and a listing agent are prohibited from discriminating against a protected class, including, but not necessarily limited to, classes of race, color, religion, sex, handicap, familial status, and national origin. Paragraph 16. Attorney fees. In the event of a lawsuit or other proceeding involving the broker's compensation, each party is responsible for their own attorney's fees and costs, unless stated otherwise. Paragraph 17. Management approval. A salesperson or broker associate often enters into a listing agreement on behalf of the broker. In most cases, this poses no problem. However, if the salesperson agrees to terms that are unacceptable to the broker or manager, this provision allows the broker manager to cancel the listing agreement within 5 days of execution. Paragraph 18. Successors and assigns. The listing agreement is binding upon the seller's successors and assigns. If, without the broker's consent, the seller transfers the property in violation of the listing agreement, see paragraph 3A3 above. The broker may prefer to act as the listing agent for the transferee, rather than sue for compensation. This provision may be used to assist the broker in convincing any transferee to continue with the listing. Paragraph 19. Dispute resolution. The parties agree to mediate any dispute arising out of the listing agreement, with certain exceptions set forth in paragraph 19b. Paragraph 19a. Mediation entails an attempt by a neutral third party to convince the contractual parties to voluntarily resolve their differences. If a party commences an action without first attempting mediation pursuant to this provision, and that party loses the case, the other party is entitled to recover attorney's fees, notwithstanding the language in paragraph 10. Paragraph 19b. Various matters are excluded from the obligation to mediate or arbitrate, including foreclosures, unlawful detainer actions, mechanics lien procedures, probate, small claims, and bankruptcy matters, notice of lease pendants, attachment orders, and receivership, injunction, and other provisional remedies. Paragraph 19C. Although there is no arbitration clause in the listing agreement, seller and broker are advised they can use a separate arbitration agreement, CAR Form ARB, if they wish to include binding arbitration in their agreement. Paragraph 20. Entire agreement. The listing agreement supersedes any and all prior negotiations and agreements between the parties regarding this matter. The listing agreement, including any photocopy or facsimile, can be signed in counterparts. Paragraph 22. Legally authorized signer. If the person signing is acting in a representative capacity for an entity and not as an individual, they will check the box in the signature section to indicate that the seller is an entity seller. The entity must be a valid entity in good standing, and the legally authorized signer will provide documentation of their authority to the broker within 3 days. Seller's signature section. By signing the listing agreement, the seller acknowledges that he or she has read and understands the agreement and has received a copy. The seller should insert the date of signature and provide an address, phone, and email information. The seller should also initial the bottom of pages 1 through 3. Entity sellers. Ownership of residential real estate is increasingly being held through a trust or in the name of an entity set up by the owner, most commonly a limited liability company, LLC, but it could be through another type of entity, such as a corporation, partnership, power of attorney, or some kind of court-authorized estate, such as probate or conservatorship. This paragraph recognizes that reality and allows for the seller's signature to be made by a person authorized to sign on behalf of the entity. Legally authorized signer. See paragraph 22. Paragraph 2 should be used to input the full and complete name of the trust or the probate case. Paragraph 3 provides an instruction for trusts and probates and what to put in the buyer field in paragraph 1. Paragraph 4 makes clear the legally authorized signer is acting on behalf of the entity seller and not for the signer in a personal capacity, and lists the individuals who will be signing. Seller signatures. Each seller signs and dates the RPA, and the printed name of the seller is included below the signature. If the seller is an entity, the RLA needs to be signed by a legally authorized signer, and the box should be checked below the line for printing the seller's entity's legally authorized signer's name to be printed, and that signer's title indicated. If there are more than 2 sellers, check the box to include the additional signature addendum. Broker signatures. The salesperson or broker associate taking the listing can complete the broker's information and sign as authorized representative of the broker. There is a checkbox for multiple agents under the same broker working on the listing, and this will attach the additional agent acknowledgement, CAR Form AAA. Also, there is another checkbox for if this is a co-listing with another brokerage, and this will attach the additional broker acknowledgement, CAR Form ABA. Practice tip. No one should sign the listing agreement until all pages have been completed. Upon completion and signature, the listing agent should immediately provide the seller with a copy of the entire listing agreement.
Ok, vente nomás. Le digo que era gated community que perdió nomás.